As Madam has said, there are two types of laws, a substantive law and a procedural law. Unless we understand this definition clearly, we may not be able to know what is the type of law that is Indian Penal Code Bharatiya Nyaya Sanhita and what is the type of law that is Bharatiya Nagarika Suraksha Sanhita 2023. A substantive law is one where the rights, duties and liabilities of the parties are defined. Take for example, as Madam has said, Indian Penal Code, that is Bharatiya Nyaya Sanhita. It is a substantive law. It is a substantive law because the law does not say you don't do that, you don't do this. It only says if you do this, you are punishable with this. If you commit a murder, sentence is death. They don't say don't commit murder. Take for example a civil case, a Transfer of Property Act. Transfer of Property Act is a civil law. It is a substantive law because it defines what do you mean by a property, what do you mean by sale, what do you mean by mortgage, what do you mean by gift, what do you mean by lease, license, etc. So that only tells you about the rights, duties and liabilities of the parties involved in a transaction. But that itself is not enough. If a person has suffered on account of an act or omission which has been made punishable under any law for the time being in force. I am using these words consciously because we are talking about Bharatiya Nagarika Suraksha Sanhita and Bharatiya Saksha Sanhita. Unless we know what do we mean by an offence, we will not be able to understand both the acts. The word offence has been defined in the Criminal Procedure Code and an equivalent provision in Nagarika Suraksha Sanhita also as under any act or omission which has been made punishable under any law for the time being in force is an offence. All acts and omissions are not punishable. At the most, the person who has suffered may claim damages from the court. That is a civil law. But if any act or omission has been made punishable under any penal law, either with an imprisonment or fine or both, that is called as an offence. So to constitute an offence, a person must have done something which ought not to have been done, or a person must have omitted to do something which he ought to have done. And such an act or omission must have been made punishable specifically under a particular provision of the penal law. That is called as an offence. Why I am telling about this? I am telling about this because the Indian Penal Code, that is Bharatiya Nyaya Sanhita and Bharatiya Nagarika Suraksha Sanhita, are interconnected. Why? Because Bharatiya Nyaya Sanhita speaks of the substantive law, as I told you already. But Bharatiya Suraksha Sanhita speaks of the procedure. What is that procedure about? Supposing I have been assaulted by somebody, or supposing my pocket has been stolen by somebody, I am the victim, as Madam has put it. So that will become an offence under old section 378 of the Indian Penal Code and the relevant section in the Bharatiya Nagarika Suraksha Sanhita. That is there. So Bharatiya Nyaya Sanhita says it is a theft. Punishment is 3 years. Fine. But how to go about? Where to go for redressal? Which court I should approach? What is the manner in which I should approach? That is procedure. So that procedure is mentioned in Bharatiya Nagarika Suraksha Sanhita. Therefore, if you want to understand the criminal law properly, I don't say thorough understanding, because thorough understanding is for people who are actually involved in the judicial process, like judges, advocates and all that. At least for you people, at least because you're all responsible persons from the media, you people should know how the system works. How the system works.
ಇದು ಏಷ್ಯಾನೆಟ್ ನ್ಯೂಸ್ ನೆಟ್ವರ್ಕ್ ಪ್ರಸ್ತುತಿ.
ನೀವು ನೋಡ್ತಿದ್ದೀರಾ ಏಷ್ಯಾನೆಟ್ ಸುವರ್ಣ ನ್ಯೂಸ್.